Good afternoon, everyone. I'm delighted to see all your names on my participants list, but actually, unfortunately, I can't actually see you. Thank you for joining this Palm Court Chambers Cohabitation Team Lunchtime webinar on the very riveting topic of enforcement and appeal. I'm Jennifer Lee. I'm a barrister at Pump Court Chambers in London. I specialize in financial remedies work, Schedule 1 cases concerning financial provision for children, and Talata. So this will be a whistle-stop tour on enforcement and appeal in the context of cohabitation cases. Um, you'll be pleased to know that the talk will be fairly short. I plan to speak for about 30 minutes or so. We can then move on to Q&As. I should also say at the very outset, I'm suffering from quite a bad cold, which you can probably tell. And so if I start coughing or sneezing uncontrollably, I might just have to switch off my camera and come back. Um, I'll be starting with appeals in both civil and family proceedings because cohabitation cases tend to straddle the two jurisdictions. And so I think it'll be helpful for us to have an overview of the two jurisdictions. And I wanted to share this image with you because I think there is some truth in that. But of course, really, I think by and large, our judges try their very best to get things right. Inevitably, however, with the best will in the world, sometimes the wrong decisions are made for various reasons, which is why it's important to have the right of appeal. And actually, Judge Dredd is a good example because I'll be coming back to that judge. I will start with the civil framework. So very quickly, and I don't mean to bore you with the civil procedure rules. The relevant provisions are in CPR Part 52. There are practice directions 52A to 52E. The test is this. It's in bold on the slide. It's the same in family proceedings as well. An appeal against a decision made by a lower court will only be allowed by a higher court, the appeal court, where the lower court's decision is wrong or unjust because of a serious procedural or other irregularity. So it's a test which I'm very sure will be familiar to all of you. Most decisions will require permission to appeal, and there are two routes for that. The first is to ask the lower court, your trial judge, for permission to appeal at the time the decision is given. And that's considered to be very good practice. It's not mandatory. That's not mandatory on your part. But sometimes I actually think there are obvious advantages to seeking permission from the lower court. It saves time and costs. You would be making submissions whilst the matter is fresh in the judge's mind. But of course, I appreciate it's also not easy to seek permission to appeal from a judge in respect of a decision that that judge has made. But in certain cases, it would save time and costs. And depending on the case, you might have a judge who is amenable to granting you permission. The second route, of course, is to lodge an application for permission with the appeal court. I should also say before I move on from this, if the complaint on your part is that the decision fails to consider a number of factors, or if the reasoning has not been given in sufficient detail, advocates have a duty to raise those matters with the judge and invite the judge to give better or more detailed reasons before you launch into an appeal. And so that's an important point. seek clarification or amplification of the judgment from the judge. If you are still not satisfied with the decision given, then you can make that decision as to whether or not to appeal. If permission was refused by the lower court, or you haven't applied for it, then lodge your application for permission to appeal with the appeal court. That's got to be done in the appellant's notice, form N161, which is in fact also the same form you would use in family proceedings. The time frame is important. You must file your appellant's notice within 21 days from the decision you wish to appeal against. The time starts running from the day you receive that decision. So from the date judgment is formally handed down, not from the date that your order has been finalized or sealed by the court. Okay, so from the moment judgment has been handed down, the decision has been made, the clock starts ticking. If the deadline is missed, you must apply for permission to appeal out of time. And if the issue arises, effectively the court will be applying the relief from sanctions test. So scrutinizing the length of the delay, reasons why you've made the late appeal, the merits of your appeal, and any prejudice which would be caused either way if the appeal is granted or not granted. When will permission be granted? CPR 52.6 governs that, and the wording actually is identical to the equivalent provisions in the family procedure rules. So permission to appeal will only be given where the court considers that the appeal will have a real prospect of success, or there is some other compelling reason why the appeal should be heard. What is real prospect of success? Effectively, real prospect means the prospects must be realistic, not fanciful. So if you have realistic prospects of your appeal succeeding, you should be granted permission to appeal. And the view adopted by judges, and certainly in my experience, the test doesn't require any analysis of the mathematical probability of success. It's not whether or not it's 55% or 60%. As long as the prospects of success are considered to be realistic, that should be sufficient to meet the test for permission. Applications for permission will normally be considered by the appeal court on the papers. Most definitely, if you are going to the Court of Appeal, the default position will be a single lady or lord justice of appeal carrying out a paper exercise, unless the judge considers an oral hearing is necessary in the interest of fairness. That will be the general approach, a paper exercise. If you are appealing to the county court or high court, so a circuit judge in the county court, for example, if that appeal court, normally they will consider it on paper, but not always. But if there is a paper application to consider your application for permission, if permission is refused, the appellant has the right to request an oral hearing, but it has to be done within 7 days of the notice refusing permission to appeal. However, if the paper exercise is carried out by a certain level of judge, and what I mean by that is if it's a high court judge, a designated family judge, or a nominated financial remedies court circuit judge, if that judge determines your appeal on paper and considers it to be totally without merit, that judge can go on to refuse an oral hearing. And so just be mindful of that. If your appeal is totally without merit, or if the other side's appeal is totally without merit, that judge can refuse an oral hearing and the matter would end there. But otherwise, an appellant will have the right to request an oral hearing, as I've said a moment ago. Also, just briefly, if you are the respondent and you actually also disagree with the decision and you are seeking permission to appeal, or if you actually want the appeal court to uphold the lower court's decision, but for different and or additional reasons, which can sometimes happen, because you might think that actually the lower court has reached the right decision, but there are additional grounds which would support that, or actually other grounds which that judge had not considered. And so you might want to protect your position in that regard. If the appellant is going ahead with an appeal, then you must also file a respondent's notice. It's in form N162. And you must do that, because if you don't file your respondent's notice, then you won't be allowed to argue additional points in the appeal court if matters go that far. I've set out the destination or routes of appeal and the different level of judges on that slide there. Always check the relevant practice direction, CPR or FPR, just to make sure which level of judge can hear your appeal. In certain circumstances, it's also possible to appeal to the court or judge above the one to which your appeal would normally lie. And we call these leapfrog appeals, where there is an important point of principle or practice, or there is some compelling reason why the Court of Appeal should hear the appeal. It's used very rarely, but of course it does happen. And in some cases, actually, you can also leapfrog straight to the Supreme Court. It's obviously even more unusual, but I mention it because a very good example in the family sphere, which many of you will be familiar with, is the case of Hassan ul Hassan, which again might ring some bells. It's that case where a question was raised as to whether or not a financial remedy claim survives the death of a spouse. And in that case, Mr. Justice Mostyn allowed a leapfrog appeal from the High Court straight to the Supreme Court. So what happens once you have secured your permission to appeal? You're delighted, of course, but then you come in front of Judge Dredd. So the test in relation to a substantive appeal I've covered in the earlier slide. So to recap, the test on a substantive appeal is an appeal will be allowed if the lower court's decision was wrong or was unjust because of a serious procedural or other irregularity. CPR 52.21 and the equivalent provisions in the FPR says that the exercise on the substantive appeal itself will be limited to a review of the decision of the lower court, unless a practice direction makes a different provision, or if the circumstances of the individual appeal means that it will be the interests of justice to hold a rehearing. So for instance, a rehearing might be appropriate if the judgment of the lower court is so inadequately set out, so lacking in reasons, that it's actually not possible for the appeal court to determine the appeal justly without a rehearing of the issues. Or, and I've had experience of this, if there is a very serious procedural irregularity which prevented the appellant from developing his or her case properly in the lower court, that might result in the appeal court taking the view that a rehearing would be appropriate. I should also say that unless the court orders otherwise, on appeal, the appeal court will generally not permit or receive evidence which was not before the lower court. If you want to adduce fresh evidence, there are various hurdles which have to be crossed. You've obviously got to make an application for that. It is effectively the principles arising from a case called Ladd and Marshall, whereby you have to evidence to the appeal court that the reasons why this fresh evidence was not available in the court below, and also that the fresh evidence would actually make a significant difference to the outcome. And thirdly, that actually it's evidence which is probably accurate or probably true. So not something which is again fanciful or evidence which really has no substance to it. It's quite difficult to get permission to adduce fresh evidence, but it can sometimes happen, particularly if you can show that the evidence could not have been available at the earlier time. And particularly if actually it's a pretty much knockout blow if this fresh evidence were to be admitted. Again, just coming back to the overriding objective in trying to show that the fresh evidence you want to admit would make a material difference. Moving on, if you have, moving on, if you have been victorious in your appeal before the Court of Appeal, before the appeal court, the powers available to the appeal court are extremely wide-ranging. The relevant rules provide that the appeal court has all the powers of the lower court. Specifically, it can affirm or set aside or vary the judgment or order made. It can order that the lower court reconsiders a particular issue. It can order a new trial or a new hearing before the lower court. In some cases, the appeal court can actually make the decision itself, which can sometimes happen. The appeal court can also, of course, make an order for costs. It can order payment of interest. And sometimes actually it can you can win on an appeal. Your appeal will succeed, but ultimately the appeal court could go on to dismiss your appeal because no further purpose would be served by a further rehearing or a further decision being made, particularly if circumstances have changed or developed to the extent by which when you reach the appeal court, that appeal becomes completely irrelevant. So that again can sometimes happen. The structure for appeals in family proceedings is very largely identical to the civil route. You would use the same form N161, but if you're appealing to the family division of the High Court, there is a different form. Appeals are generally approached as a review as well in family proceedings. But I would say that family courts would be much more amenable to considering a rehearing on an appeal, particularly if the child's welfare would require such an approach to be taken. The time limits are the same, so 21 days from the decision you are appealing against. But just bear in mind that for family proceedings, if you are appealing against a case management decision, the time limit is very severely curtailed. You would only have 7 days. So 7 days for case management decisions in family appeals. Permission to appeal, again, would be required. The test for permission is exactly the same. I won't repeat it. It's on the slide. And again, the test on the substantive appeal is also identical, where the lower court's decision was wrong or unjust because of a serious procedural or other irregularity. Right. So that deals with appeals. I will take questions and answer your questions at the very end. I'll move on to enforcement at this stage. And I want to start with the court's powers to execute documents, which I actually think can be enormously helpful on a practical level when you are dealing with a sale of a property or transfers of property, or, in Schedule 1 cases, thinking about executing trusts of a property and so on. The power is not confined to conveyancing documents. It's actually, in theory, that power can be used to execute all sorts of documentation. The starting point is the legislation. So the power is found in Section 39 of the Senior Courts Act of 1981. And I'm just going to highlight what that particular legislation says. It says, where the High Court or Family Court has given or made a judgment or order directing a party to execute any conveyance, contract, or other document, then if that person neglects or refuses to comply, or cannot, after reasonably inquiry, be found, the court may, on such terms and conditions, order that the conveyance, contract, or other document shall be executed on behalf of that person. So the wording of the legislation is important because it depends on the court making an order which directs a party to execute a specific document or class of documents by a specific time and date. So when you come to draft orders, or you invite the judge to make orders, please just make sure that you include this particular direction. This power cannot be relied upon unless there is this specific direction directing that party to execute, to complete, sign that document by a certain date and time. It's a basic requirement which goes to the ability of the court to exercise Section 39. Welch and Welch, which is a decision of His Honor Judge Hess, sets out the procedure to be followed if you are asking a district judge to execute a document under Section 39. Follow that procedure. Arguably, I mean, there are 4 stages to this. I've set them out on a slide. I won't go read them out to you. But I would say that arguably, stage 3, where it says that the court will then order the other party executes the document by a certain date, by inviting your judge to make that direction in the final order, directing that party to execute the document by a certain date, you can very conveniently bypass stage 3. So you'll be saving time and costs by doing so. Okay? It would obviate the need for having 2 separate applications. There is some debate as to whether or not when you draft orders, you can have an anticipatory order. And what I mean by that is you would have a direction directing a party to complete, sign a document by a certain date, and then immediately in the same order provide for a judge to execute that document in default of that party complying with the directions above. So there is some debate as to whether you can have the 2 built into one order. But in my experience, I've dealt with many cases where that has been the norm, and judges have not queried that provision when it comes to enforcement. I know that His Honor Judge Hess supports that approach, in fact. And also, I think it's to be noted that the standard template orders actually provides for that mechanism as well. So I would say that you should rely on that. You should be able to make anticipatory orders. There is support for that approach. And in my experience, given it's set out in the standard template orders, you would probably be hard pressed to find a judge who would argue against that. So it saves you time, it saves you money. You might as well build it in to ensure that there is as smooth compliance as is possible down the road. There are different methods of enforcement, and I just want to move on very quickly to those. I'm going to approach enforcement from the perspective of Schedule 1 cases, but the methods that I'll be covering in a moment will also apply and will be available in civil proceedings. For family, the Family Procedure Rules Part 33 would govern enforcement. You can make a general enforcement application, so seeking such method of enforcement as the court would deem appropriate, or you can take a more targeted approach. So apply for specific enforcement methods, which I actually think if you can, provided you know enough about the assets of the defaulting party, it tends to be my preference because specific applications for specific methods of enforcement tend to have more truncated procedures. So you would have fewer hearings. And I also think it focuses everyone's mind, including the judges, as to what assets you can target. I'm a great fan, starting firstly with charging orders, where if you have a debtor which who owns property, but actually not only real property, if you have a debtor who has shares, investments, securities, funds paid in court, you can have a charging order which secures the sums owed against those assets. And it's, in my view, a very streamlined approach. It tends to be dealt with as an interim order first. So it will be dealt with on the papers by a district judge. You can have it done, secured as an interim charging order very quickly at relatively modest cost. And you would then go on to a full hearing at which the other party can then make representations. But in my experience, certainly in the cases I've dealt with, by that stage, I mean, once you have an interim charging order, it tends to be miraculously that the other party will find the money to satisfy your judgment debt or the sums you are owed. And so you wouldn't even need to get to the final charging order stage. So I find that charging orders are actually incredibly effective if you have assets that you can charge against. We also have third-party debt orders, again, very helpful. I don't know whether, I mean, my impression is that people don't use third-party debt orders enough. If the debtor has monies in a bank account held to their credit, so the bank owes the third party, owes the debtor sums of money, apply for a third-party debt order, because that immediately, again, would secure a sum of money in the bank account. It would divert the obligation of the bank paying the monies to the debtor, diverting that obligation from payment to the debtor to payment to you or your client. And again, there is a mechanism by way of you being able to apply for an interim order, interim third-party debt order, which would freeze the monies in the account, or I think freezing is probably not the right word. It would direct the bank to ensure that there is a certain level of money in the bank account which would not be paid to the debtor. And so it would hold the ring until you can get to your full hearing. And again, very similar to the charging order, I find that by that stage, the debtor will often find the money to then discharge the sums owed to your client. Attachment of earnings order. This requires the employer to deduct sums of money from the debtor's earnings. That sum of money would then be paid onto your client. There's a specific form which is required. You would make that application with a statement in support. Again, I think attachment of earnings orders are extremely helpful, but provided, of course, you have a debtor who is in employment, a debtor who has an employer who is subject to the jurisdiction of the court. Because in my practice, and I deal with quite a lot of cases with international elements, it's often not very easy to identify, firstly, who the employer is, but also secondly, even if you can identify the employer might often be overseas in a jurisdiction which is simply out of the reach of the court. And even for very big companies, if you were to serve them with an English order, an attachment of earnings order, in my experience, they tend to ignore it because they're outside of the jurisdiction of the court. So just something to think about when you consider attachment of earnings orders. The writ or warrant of control, I mean, writ is just a very fancy word that they use in the High Court. A warrant of control is used in the family court. If you have those cases where the debtor has valuable personal items, collections of paintings, valuable furniture, Patek Philippe, Cartier watches, car collections. Again, don't forget that the court can enforce against those assets. And actually, in the right type of case, they can be enormously effective. I remember a case I did about 2 years ago where the husband had a very, very valuable collection of cars, his pride and joy. We were able to secure a warrant against 3 of those vehicles. And lo and behold, the monies were found to pay my client's lump sum, nearly £500,000 were found pretty much overnight. So I think, again, it's just about thinking about where you can inflict the maximum pain or damage and going for specific assets where you can. Want to move on to a couple of nuclear options. So these are the potentially more drastic solutions. We have the appointment of a receiver, an officer of the court, who will then take steps to bring in the debtor's assets, will then try to extract payment from the debtor's available assets, pay the creditor the money, effectively pretty much like an insolvency practitioner. Again, very much a draconian option, but can again be enormously effective if the only way to elicit payment is to go down that route. Judgment summons, very similar to a committal, but actually not the same thing. A judgment summons is available if you have a debtor who is in breach of an order to pay money. So periodical payments or lump sum orders. And the court will need to be satisfied beyond reasonable doubt. So the standard is high. It's the criminal standard of proof, beyond reasonable doubt, that the a debtor has had the means to pay but has refused to pay. And if you succeed in reaching that threshold, the debtor can be committed to prison for up to 6 weeks for contempt. Normally, I've dealt, and again, just thinking back, I think in my career, I've dealt with maybe 5 judgment summons, which have reached a stage of us all robing up and going to court. I can count on one hand of the 5, I think there were 2 cases where the debtor was actually committed to prison And even in those two cases, the prison sentences were suspended because, of course, it's an extremely draconian measure, but it works. I mean, if you can, and it's a very serious issue of breach, consider that. In those cases that I've dealt with, three of them actually we didn't have to go to trial. We settled on the door of the court because, again, miraculously, money was found. And of the two cases where the sentences were suspended, again, suspension for a number of weeks for the monies to be found. And again, in those two cases, the monies were found. Committal is very similar, as I've said, but different. Committal is where there is an order to do or not to do something. So it's not about payment of money. And it can be enforced, again, by way of committal, so being sent to prison. But your order to do or not to do something must, of course, be endorsed with a penal notice. Finally, I've been talking for about 40 minutes now. Finally, I just want to raise a couple of factors to think about if you are dealing with cohabitation cases. Of course, there is enforcement via the Child Maintenance Service if there are arrears of child support pursuant to a CMS assessment, but we all know the CMS is pretty woeful. But that, in theory, is an option open to your client. We have Hatkinson orders, where a party is in serious breach, repeated breach of orders. The court can limit their participation in proceedings, and I mean proceedings on an appeal or proceedings where you are taking out enforcement proceedings. So think about Hatkinson orders as well. Injunctions are very useful in the court's armory if you have assets which need to be frozen in interim. And also, finally, I don't think many people are aware of this provision, but in Schedule 1, paragraph 12, the legislation says that any person who is under an obligation to make payments of money under Schedule 1 must give notice of any change of address as may be specified, and failure to do so is a criminal offence. And so just again worth bearing in mind that there are these specific provisions, in this case in Schedule 1, which places an obligation on the payer to provide you with up-to-date information. And this is just one of them. I mean, failure to do so would be a criminal offence, so obviously quite a serious thing. So something, again, that you might deploy in the right sort of case. Thank you very much indeed for joining. Hugely appreciate you giving up your time this afternoon. Thank you very much indeed, and a very good afternoon to all of you.